Hello. Alright, so this is These Weird People News. Okay? This video is without prejudice and without recourse, okay? I'm not an attorney, not giving legal advice. Just opinions only. Do not take it as legal advice, people. I'm not an attorney, nor care to be, by the way. I don't want to be bound to the bar unions. And I won't be able to have my free speech when I'm operating in courts. Okay? This is going to be an interesting video. Okay? We kind of call it really jurisdiction. But to realize that you keep on hearing the civil law. Well, it's a civil law. Civil law this, civil law that, civil law. Right? However, do we fully understand what they mean by when they say it's a civil law? Alright? We adopted civil law from Rome. So it's a Roman civil law. So there is 12 presumptions that we got to do a rebuttal for. And I'm glad I found this video. I do have another one somewhere. I just cannot remember what it's called, the name of it. But what it is, in my other video, is called the 12 jurisdiction. Okay, I didn't name it that, but that's what it was. It's 12 different jurisdictions. That's what we call it. Jurisdictions in the United States instead of Roman civil law. Why? Because the name itself sounds scary, so they had to cover up. Remember on my videos about trickery of words. Alright, so the reason why I was bringing this video up is because anytime you do any type of court cases, you want to do these 12 rebuttals, no matter what the case should be.
The 12 presumptions of court. All shall be considered rebutted. Canon 32:28. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, and are therefore...
Oh, P.S. Anything you hear about canon, it's Roman.
...that you stand true, or as truth in commerce. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor/beneficiary,
silence of acquiescence. In short, y'all, if you stay in silence and acquiescence, basically that's number one. Well, all of it's silence and acquiescence. You got to rebuttal everything. But, what is it? Silence and acquiescence and tacit agreeing to the court's terms by being in silence and acquiescence. So you tacit agreed that we accept this Roman law.
Executor de Santor, incompetence and guilt. Number 1. The presumption...
Sorry, let's go ahead and read by that one more time so I don't interrupt it and get a clear view.
The private bar guild are not rebutted, they become fact, and are therefore said to stand true, or as truth in commerce. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor/beneficiary, executor de Santor, incompetence and guilt. Number 1. The presumption...
Okay, we're going to stop right there. So when they say bar guilds, we just call it the bar. But you guys also heard the bar of England, bar of Rome, bar of the United States. They're all tied in together, y'all. Whether you want to believe it or not, it doesn't change the fact that it is. Okay? Just saying. And I don't even think most attorneys actually know this, to be honest with you.
Of public record is that any matter brought before a lower Roman courts is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains a private bar guild matter, completely under private bar guild rules. And, number 2, the presumption of public service is that all the members of the private bar guild, who have all sworn a solemn, secret, absolute oath to their guild, then act as public agents of the government or, quote, public officials, unquote, by making additional oaths of public office that openly and deliberately contradict their private, superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. And
I had to take that a step further, right? So they say the private bar association, right? Now remember, y'all, if they're not private, if they are actually private, then they have to have a license to be a corporation in the United States, in Texas, okay? So the Bar of Texas is a private business because they had to be licensed from the state to operate their business. Okay? And then lawyers had to pay union dues to practice law and for their protection, just like any other unions. That's all it is a union. But it's a private union. That's the reason why they have so much power, is because it's private. People have a tendency to say, I want to stay in the private, not in the public. Well, that's what that bar association is, right? It's in the private. But their attorneys and their employees itself is in the public. But the corporation's in the private. And really, when was the last time anybody on the bar board has actually been charged for anything?
And number 3, the presumption of public oath is that all members of the private bar guild, acting in the capacity of, quote, public officials, unquote, who have sworn a solemn public oath, remain bound by that oath and therefore bound to serve honestly, impartiality, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. And, number 4, the presumption of immunity is that key members of the private bar guild in the capacity of, quote, public officials, unquote, acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability. Unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild, as public trustees acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. And, number 5, the presumption of summons is that by custom, a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit to or attend. Jurisdiction and position as the accused and the existence of, quote, guilt, unquote, stands. And, number 6, the presumption of custody is that by custom, a summons or warrant for arrest unrebutted stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by, quote, custodians, unquote. This includes the dead legal fiction non-human, quote, person, unquote, that corporate governments, rules, and regulations are written for. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul-possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands, you are a thing and property, and therefore lawfully able to be kept in custody by custodians. And number
Custodian. All right, means not mine. Okay. Remember, a corporation. 18 USC. Wait a minute. Scratch that. 28 USC 3002. 15A. The United States is a corporation. Not my laws. That's the government's laws. Just saying.
7. The presumption of court of guardians is the presumption that, as you may be listed as a, quote, resident, unquote, of a ward of a local government area and have listed on your passport the letter P, you are a pauper and therefore under the, quote, guardian, unquote, powers of the government and its agents as a, quote, court of guardians, unquote. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter before the court, the presumption stands and you are by default a pauper and lunatic and therefore must obey the rules of the clerk of guardians, which is the clerk of magistrates' court. Number 8. The presumption of court of trustees is that members of the private bar guild presume you accept the office of trustee as a public service and, quote, government employee, unquote, just by attending a Roman court. As such, courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged, used to state you are merely visiting by, quote, invitation, unquote, to clear up the matter, and you are not a government employee or public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you, quote, appeared, unquote. And
So then think about that for a minute, y'all. Why do you think, number one, officers not smart enough to think on their own? However, the other part of it is, why do you think they keep going by policies and statutes and codes? Right? It's the corporation part. Because the Constitution, state or federal, don't have statutes and codes and all that. Right? It goes by common law. Common law has no statutes or codes or regulations or anything like that. So, that being said, anytime you hear statutes, codes, policies, and this, that, here, and there, it's the corporation, y'all. Let's start putting these two and two together and realize what's causing us harm. Alright? And I'm just voicing my opinion. I'm not an attorney. I'm not giving legal advice. Okay? But come on, y'all. Sit and think about this. If you're part of a corporation, and they assume you're part of a corporation, then in fact, you have no constitutional rights. And that's what they keep saying in court, right? You have no constitutional rights in my court. Why is that? They're assuming you are part of their corporation. You are an employee of Walmart. Alright? If you work for Walmart, you have no constitutional rights.
Number 9, the presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoint the judge/magistrate in the capacity of executor, while the prosecutor acts in the capacity of the beneficiary of the trust for the current matter. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, trust, before the court, the presumption stands and you are by default the trustee, therefore must obey the rules of the executor, which is the judge/magistrate. And number 10, the presumption of executor de Santor is the presumption that if the accused does seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an executor de Santor or a, quote, false executor, unquote, challenging the rightful judge as executor. Therefore, the judge/magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation, unless this presumption is openly challenged by not...
What? What to do to these people that actually stand up for their rights and challenge jurisdiction in the courts? Oh, we need to have him have a psych valve He's not able to handle the matter on his own. Why is that, y'all? Okay? I'm just saying, y'all. Put two together. Are they or not doing what they just exactly said on here?
Only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de Santor, the presumption stands, and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert their false claim. And 11. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge/magistrate as executor has the right to have you arrested, detained, fined, or...
Ignorance are no excuse of the law, right? They're presuming your ignorance of the law. Which rightfully so, because every time we turn around, what do? Instead of doing our research, we ask an attorney, and we actually operate what the attorney says, which is hearsay, because you don't do the research on your own, people.
Or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent. Then the judge or magistrate can do what they need to keep you obedient. And, number 12, the presumption of guilt is the presumption that as it is presumed to be a private business meeting of the Bar Guild, you are guilty, whether you plead guilty, do not plead, or...
Okay, this is the very serious part right here. We've talked about this over and over and over. Not guilty, no contest. Guilty, right? Not guilty means you are guilty. The states just can't prove it. That's the reason why they enhance it. Never has innocent in there. That's what I said a few videos back, right? They said all these 3 things on my ticket. And I scratched all that out. I put a little box on there. I put innocent on the side, checked it out. Gave it back to the clerk. And it says, well, you can't do that. I said, well, all this right here is false. I mean, none of these 3. So why am I making a plea? I'd be lying to the courts. I'm giving false pleadings. Needless to say, that court did get dismissed later on, but, you know, they did take it, and I didn't make a plea. They gone ahead and made me, the judge acted like an attorney and made the plea for me.
Plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. This is the 12 presumption.
Now, so I didn't think about this. I talked about the due process, right? This is all violations of due process, by the way. Okay? They're going by assumptions and presumptions and not facts. All right? And again, what? You're guilty until proven innocent, people. All right? How does that come about? Okay? Just saying. All right. I think I've been on this video long enough.
Of court.
Anyway.
Hi, my name is Mark Joseph, and I'm a...
I guess we'll stop right there. That was a coincidence. Alright, y'all. This is Diesel We the People News. Check this video out. Share it, because we need to know these 12 things they are doing to us. And it's kind of hard to stand your ground if you don't know these 12 things to rebut. Rebuttal is very important. And making these plea, no. Quit making these plea. Force them to make the plea on you. And then force that judge and tell them, okay, well, now you're held responsible. You made the plea for me, so now you are acting as my attorney. And I expect you to sit right beside me during my court hearing. This will be the People News. Bye, y'all.